Good morning, dear students, particularly the first semester students for whom the law of torts is being told. Right. Today we are going to discuss an important topic regarding the general defenses to the nature of torts. Normally, as advocates, you should try to defend so-called your defendant or the accused or the tortfeasor. You all know that tort is a civil wrong which is not a breach of contract or which is not a breach of trust, and when the legal injury is caused, it can be remedied by way of compensation in the shape of unliquidated damages. This is basically the definition, right? So there are so many umpteen number of defenses, so you can defend your client. Four are majorly important, already we discussed the same. First is Volenti non-fit injuria. Second is plaintiff the wrongdoer or ex turpi causa. Third one is inevitable accident. Fourth one is this nature or act of God. Then you can go for a private defense, mistake, necessity, then during the statutory authority or government authority, then judicial acts, then parental or quasi-parental authority. I told you the dilatory defense and also contribute negligence. They are not much important. Today we will concentrate only one topic, that is Volenti non-fit injuria. That means damage suffered by consent, voluntarily, consent or willingly. If you know the damage, if you are going there and get damaged, you can't claim any compensation. That is, you do not have any cause of action. No compensation need be paid. So, in summary, VNFI, Volenti non-fit injuria, means the damage suffered by consent is not a cause of action. Right? Normally, you will be going to the cricket match, you will be going to the horse racing, you will be going to the car racing. So normally you try to be in the first seats or something like that. You wanted to see the match not from the back side but from the first side. You know that if by mistake the ball comes and hits you on the head, definitely you will get injured. If the cars come, definitely you will be injured. But still you volunteer it. So if such is the case, even though you receive injury, you can have the defendant, the other side will have the defense of saying that he has volunteered, that is Volenti non-fit injuria. That's why you can escape. No doubt it is a tort, but you can have the so-called defense. This is a defense theory. Definitely it will be useful to your clients. Right? We will discuss a couple of case laws, important case laws. One is Hall versus Brooklands Auto Racing Club, 1933. So our friend Halls, he went to the racing club. Of course, the cars were racing. Incidentally, two cars collided with each other and they came onto the edge and fell upon the area where the plaintiff defendants were actually seeing, and plaintiff and others, so many received injuries. Then he filed a case of negligence, or he filed a case for compensation under the law of torts. But after seeing the arena, after hearing the arguments of the other side, the High Court, or at that time only we can call as the Privy Council or House of Lords at that time, they did not give any order, any compensation to the victim, because basing on the principle of Volenti non-fit injuria. Of course, other factors also there. So this racing club people, they have shown their diagrammatic representation of the club. It was in the so-called almond shape, because almond shape, and they have actually erected a barricade. Then they have made some greenery, and then only they have allowed the persons to sit. But incidentally, the accident happened. We can't help it, because they were running at a heavy speed. They collided, fire came out, and ultimately one of the cars actually drove into the air and fell upon the person, the so-called Uyers, out of whom Mr. Hall is one of them, and he received injuries. So since they have already taken so many precautions, even right in the construction of the stadium, then there is no negligence on their part. And basically here what you have learned is, since our man has volunteered to go and sit in the front row, so he cannot get any compensation. This is a very good, beautiful case law. And second one is regarding the photographer. That is Woolridge versus Sumner. Woolridge versus Sumner, 1963. Right, Woolridge was a photographer. He's a professional photographer. He went into an auto racing, this is horse racing club, and he wanted to take the photographs of the jumping horses or howling horses, all these things. Of course, a deck was arranged for all the photographers, and actually he stood in the edge of the arena, edge of the step. So while he was busily engaged in taking photographs of the horses and galloping the horses, and incidentally before his when he was about to take the photos, the so-called horse rider, he has galloped the horse to such an extent that this man got frightened and fell down from the arena, and he received in the race. He claimed for damages, but the cause of Lords denied. They did not agree because you yourself volunteered to take the risk. You stood on the edge of the stood on the edge and fell down from there. So your claim is rejected. Right? Of course. Here, even though I tell you Volenti, non-fit injuria, there are certain limitations also. Suppose some people know the risk, but still they have to work because to eke out their livelihood or poverty or out necessity, definitely. In such a case, the defendant cannot take the exception of Volenti, non-fit injuria because he has to take more precautions. This happened in the case of Smith versus Baker. Yes, 1891, Smith versus Baker. Actually, what happened is, it has come in appeal. Actually, the Baker filed a case against Smith, but of course, since they have gone in appeal, now you can call it as Smith versus Baker. Baker was working as a cutter in the actually in the mines of the so-called Smith company. Right, he was a cutter. That means he used to cut the rocks, and he will separate them. A crane will come, take away the rock, and at another place it will be made into some this thing, polishing, other things will go on. So Baker knows that whenever he drills, some danger may come, and whenever the crane takes away the so-called cut rock, then there may be some difficulty if it is false on him, but still he has accepted the job. Same thing happened on one day while he was cutting and drilling, and while taking away the already cut rocks, the so-called crane slipped and the rock fell on our Smith. He received injuries, received very serious injuries. Right. Then he filed a case for compensation. Of course, the company, Smith and others, they pleaded that it is Volenti, non-fit injuria. So he knows that the risk is there, he volunteered it, we need not pay any compensation. But the House of Lords held that mere knowledge on the part of the defendant was not sufficient. The plaintiff, that is Smith, should have taken due care and diligence towards his employees. Is it not? When you think that there is some risk, definitely you have to take precautions. So there is negligence on the part of the Mr. Smith, and therefore, since he failed in his duty, so it can't be said that he's got a Volenti, non-fit injuria. Therefore, the employer, that means Smith, has to pay compensation. So these are the three examples I've given. So this video is made only for the purpose of examination. That's all. So please remember these cases and write notes, and definitely you will get success. Thank you very much.